First of all, both Eva and I would like to thank the colleagues from Maribor for the kind invitation to participate in this seminar. We would also like to extend our thanks to the participants. Our intervention will be divided into two parts. In the first part, on the basis of two case studies, we will deal with some issues related to the European Order for Payment procedure. And in the second part, we will do the same in order to reflect on certain questions on the European small claims procedure. Let us start with the first of the cases. Let's start with the first case.
Yeah, the first case, facts. Maria, a Spanish national resident in Zamora, agrees to sell her Audi A4 to Manuel, a Portuguese national resident in Oporto. The two meet each year during the holidays in the Portuguese town of Viana do Castelo, where Manuel's parents live and Maria rents a holiday apartment. In the summer of 2018, Maria mentions to Manuel that she's trying to sell her car and Manuel expresses an interest in buying it. They agree on a price there and then 3,500 euros and sign a purchase agreement for the car in August 2018 in Viana do Castelo, whereupon Maria delivered the vehicle to Manuel and Manuel pays an initial installment of the agreed purchase price, 2,000 euros, with a commitment to pay the remainder 1,500 euros in December of the same year. In September, Manuel loses his job and is consequently unable to make the remaining payment on the vehicle he purchased. Following several payment requests for the outstanding amount, Maria decides to apply for an European payment order in the Court of First Instance in Zamora, including in her applications Manuel's parents' address in Viana do Castelo, where she knows Manuel to be living at the time. The court issues a payment order in Manuel's name without acknowledgement of receipt.
Well, thank you, Eva. On the basis of the facts that have just been set out, there are two questions on which we will focus. The first is to determine which court has jurisdiction to decide the case. The second concerns the place and method of service. As far as jurisdiction is concerned, we know that Article 6 EOPP regulation refers in general to relevant rules of community law. On the other hand, in the second paragraph, the aforementioned Article 6 establishes a specific forum in cases of consumer contracts where the defendant is a consumer. In fact, in accordance with what has been said, if the claim relates to a contract concluded by a person, the consumer, for a purpose which can be regarded as being outside his trade or profession, and if the defendant is the consumer, only the courts in the member state in which the defendant is domiciled shall have jurisdiction. In other words, the second paragraph of Article 6 assigns jurisdiction to the courts of the consumer's domicile. In our case, if the purchase had been covered by a consumer contract, jurisdiction to hear Maria's claim could have corresponded to the court in Oporto. But Maria is a private individual, not a trader, and the agreement between her and Manuel is a civil purchase agreement, not a consumer contract. As a consequence, in the proposed case, it would be necessary to have recourse to the rules applicable in the matter, in particular to Article 2 of the Regulation 1215 of 2012 of the European Parliament and of the Council of 12 December 2012 on jurisdiction and the recognition and enforcement of judgments in civil and commercial matters, hereinafter Brussels 1 bis. Well, according to Article 2 Brussels 1 bis, persons domiciled in a member state shall, whatever their nationality, be sued in the course of that member state. Persons, on the contrary, persons who are not nationals of the member state in which they are domiciled shall be governed by the rules of jurisdiction applicable to nationals of that state. Therefore, in our case, jurisdiction would correspond to the Portuguese courts. In this respect, it is true that in matters relating to a contract, according to Article 7 Brussels 1bis, a person domiciled in a member state may be sued in another member state. In such cases, the jurisdiction will correspond to the course of the place of performance of the obligation in question. And in the case of a sale of goods, unless otherwise agreed, that place is the place where, under the contract, the goods were delivered or should have been delivered. In our case, that place would be Viana do Castelo, but under no circumstances would jurisdiction ever correspond to the court of the first instance in Zamora, where Maria made her application. Once the question of jurisdiction has been resolved, we will now turn to the problems that may arise regarding the place and method of service. The place and method of service of payment orders are provided in Articles 13 and 14 of EOP regulation. In relation to our case, the way in which the payment order was served, ordinary letter post-delivered straight to the defendant's letterbox without acknowledgement of receipt, is one of the methods accepted under the EOP regulation in the interest of speed and efficiency. To ensure the defendant receives the order, however, it should be delivered to his/her home address. Nevertheless, this is not the case in this instance because the defendant is domiciled in Oporto, not in Viana. There is no way to prove that he has received the order, much less to adduce as evidence of receipt the fact that it was not returned. So, in this instance, therefore, the order could have been served with acknowledgement of receipt in Viana, or without acknowledgement of receipt in Oporto. In any case, because the method of service provided in Article 14 without acknowledgement of receipt is less reliable, European Union law also provides measures for defendants served in this way, where service is not effected in time, allowing the defendant in such cases to apply for a review of the order procedure in accordance with the time frame and conditions provided in Article 20. To initiate the review process, defendant is not required to show proof that she has not served, only that the order was served using the method provided in Article 14. Finally, it should be underlined there is no right of appeal in the EOP regulation, but the defendant may apply for a review of the order for payment as a separate extraordinary procedural measure. And consider now the second case.
Facts of the second case. In January 2017, the International Association Amigos de lo Ajeno, with registered address in the city of A Coruña, Spain, decided to renovate an office property belonging to the association in the city of Dortmund, Germany. After considering different quotes for the work, the association decides to award the contract for the work to a French company, the Molombe, which has a long track record in the building sector. The contract for the work did not include the flooring materials required, which were obtained directly from an Italian company, Cavi di Titanus. Now the work is finished. The association has outstanding invoices for payments to both companies in the amount of 5,000 euros. The companies are considering legal action to demand their respective unpaid debts using the European payment order procedure.
Well, I am a professor of civil law, and I have to admit that this case study is a pretext to highlight a possible interaction of the legal concept of consumer and the EOPP regulation as far as the determination of the jurisdiction is concerned. So, the concept of consumer varies across the European Union, owing to the different country-specific definitions used in European Union law for each member state. The question in this instance, therefore, is how to define the concept of consumer and whether an association, a legal entity, may be considered such under Article 6 of the EOPP regulation. The answer to this question has significant practical implications. If the association, Amigos de lo Ajeno, may be considered a consumer according to the regulation, then only the court of first instance, where the defendant is domiciled, a Coruña, will have jurisdiction to hear any claims made against it by Demolombe and Cavi di Titanus, in accordance with Article 813 of the Spanish Civil Procedure Act. On the contrary, if the association is not considered a consumer, then in accordance with Article 6 of the EOPP regulation, Article 7 of Brussels 1-bis regulation will apply, and the court with jurisdiction to hear any claims in relation to the sale of goods and or the delivery of services will be in accordance with the legal procedures in force in Germany, as the country in which the goods were delivered and the contracted renovation services were carried out. From the point of view of the Spanish legal system, legal entities, including associations, are explicitly included in the legal definition of a consumer under Article 3, Paragraph 2, Legislative Royal Decree approving the recast test of the General Consumer and User Protection Act and supplementary laws. On the other hand, the fact that the Spanish law establishes that only a natural person may be considered a consumer in certain matters, such as a real estate credit contracts, is a separate issue. It could therefore be argued that the protections provided in law for natural persons in their capacity as consumers could be extended to legal entities and incorporated organizations at a European level, albeit with certain restrictions and safeguards. The case law of the Court of Justice of the European Union in relation to the concept of consumer, for example, has shown a positive evolution in this direction, from an initially more restrictive definition to one more focused on the objective context of the operation than on the legal personality or subjective conditions of the contracting party. The Court of Justice of the European Union has also made it clear that there is nothing to prevent member states from expanding the partial harmonization of consumer rights in some areas to other subjects, legal entities, and even unincorporated organizations, provided the spirit of the European system of consumer protection is not compromised. So, I know that is a debatable question, but I think that it would be possible to extend the concept in a European, the concept of a consumer in the European level. So far, some reflections on the European order for payment procedure. Now, let us do the same for the European small claims procedure. So, Eva, please.
Case 3, facts. Loreto and Jorge are a married couple and have their permanent residence in Lleida. They purchase Ryanair flights online from Girona to Palma de Mallorca with the intention of spending the weekend away. When they arrive at the airport, they discover that their flight has been cancelled owing to a flight scheduling change. The company offers them an alternative flight 2 days later, which they reject. They make a claim for the cost of the flights, 124 euros, and for the expenses of the trip, 84 euros for to-return train tickets, Lleida-Girona, 230 euros for the prepared nights in the hotel that they were unable to use, and 68 euros for living expenses. Marcus,
well, in relation, thank you. Well, in relation to the facts as set out above, it should be noted that the ESCP shall only apply whatever the nature of the court or tribunal to civil and commercial matters. Furthermore, it should be necessary to take into account that the value of the claim can now exceed 5,000 euros at the time when the claim form is received by the court or tribunal with jurisdiction. And we have to exclude all interest, expenses, and disbursements. It shall not extend, in particular, to revenue, customs, or administrative matters, or to the liability of the state for acts and omissions in the exercise of state authority. And thirdly, cross-border issues must be involved. For the purposes of the ESCP, a cross-border case is one in which at least one of the parties is domiciled or habitually resident in a member state other than the member state of the court or tribunal seized. On the other hand, we know that the European small claims procedure shall be available to litigants as an alternative to the procedures existing under the laws of the member states, according to the Article 1 of the ESCP regulation. In the case in question, involving a consumer claim for 506 euros, it means that the claimants have a number of legal options available to them at both European and national level. In this sense, Article 3 of ESCP regulation states that jurisdiction will be determined in accordance with Brussels 1 bis regulation and in accordance with Article 18 of the latter, because the claim involves consumers and the claimants are consumers. Loreto and Jorge may choose to bring proceedings against the defendant either in the courts of the member state in which the latter is domiciled or in the courts for the place where they themselves are domiciled. The second option is obviously more advantageous to them and is the one we will assume for the analysis of their case. In view of the different options available, the claimant should assess the pros and cons of each one in terms of complexity, expense, likelihood of appeal, etc. The options available to claimants under Spanish law are as follows. The first possibility is to apply the rules of the ordinary oral proceedings. In this sense, the parties may request an oral hearing. Since the case in question relates to matters of transport, jurisdiction would lie with the commercial court. One disadvantage of this process is that there is no right of appeal in oral hearings for claims of less than 3,000 euros. The second possibility in the national level could be the payment order procedure. As creditors, Loreto and Jorge may also initiate a payment order procedure before a court of first instance, and that according to Article 813 of the Spanish Civil Procedure Act. While theoretically the quickest option, the debtor may choose to oppose the claim, in which event the case would be transferred to ordinary civil proceedings, as outlined in the previous point. In European law, the following two types of procedures may be used: the European Small Claims Procedure and the European Order for Payment Procedure. In relation to the first of them, the European Small Claims Procedure is an alternative to existing national procedures for claims not in excess of 5,000 euros, as in the case presented here. Representation by a lawyer or procurator is not required. As in the payment order procedure in Spanish law, in the event of opposition by the defendant, the claim is transferred to ordinary civil proceedings in the corresponding member state. The measures to facilitate the application of the ESCP in Spain are provided in the final provision number 24 of the Spanish Civil Procedure Act. In the event of the opposition by the defendant, the Spanish procedural law applies, Spanish procedural law applies, meaning that the matter is referred to an oral hearing. According to the aforementioned final provision number 24, depending on the object of the claim, first instance jurisdiction over the ESCP will correspond to the court of first instance or the commercial court. Although final provision number 24 refers to Brussels regulation, it should be understood territorial jurisdiction we will determine in accordance with the provisions of Brussels 1 bis regulation. All procedural issues not covered by ESCP will be subject to the provisions of the Spanish Civil Procedural Act in respect of oral proceedings. If the defendant opposes the procedure on the grounds that the claim amount exceeds the financial limit established, the judge will issue a ruling within 30 days of notification to the claimant of the defendant's response, determining whether to continue proceedings or transfer the claim to the appropriate civil proceedings in accordance with Spanish procedural law. The ruling of the court is not subject to appeal without prejudice to the defendant's right to present the same objections in separate proceedings against the decision. The final judgment in relation to ESCP will be subject to appeal in accordance with a Spanish Civil Procedure Act. Finally, jurisdiction over the enforcement in Spain of a final judgment in an ESCP passed in a different member state of European Union will correspond to the court of first instance of the place of domicile of the defendant. In relation to the European order for payment procedure, is another alternative available to the claimants. This procedure applies in civil and commercial claims of a cross-border nature. The special conditions of jurisdiction for consumer contracts provided in EOPP regulation do not apply in this case because the consumer is the claimant, not the defendant. In Spanish law, the measures to facilitate the application of the European Order of Payment procedure are provided in final provision number 23, of the Spanish Civil Procedure Act. If the defendant rejects the order for payment, national law will apply, and the case will be transferred to the appropriate ordinary civil proceedings, once again in the form of an oral hearing. Let us now turn to the second case.
The last case.
Yes.
Okay. In this, now we have common facts and two scenarios. The facts, the common facts. Amazonia D is an online retail company. Its registered address is in Berlin, Germany, but it provides goods and service to customers in all of the member states of the European Monetary Union through its website, which is available in several different UA languages. Andres, a Spanish national resident in Coruña, here in Spain, uses the website to buy a personal computer, a printer, and a high-resolution screen, costing €2,499, €899, and €995, respectively. Scenario 1. Following delivery of the three items, the computer, the printer, and high-resolution screen, Andres tests them out for 15 days and confirms that they do not meet his expectations. He therefore decides to return the items, cancel the agreed payment, and request that the cost of return be borne by the seller. The company considers that the reason for return stated by the customer is not covered by the term of sale accepted by Andres when he bought the items, and intends to sue him for the agreed sale price, or alternatively for return of the products and compensation in the amount of 30% of the total retail price. In accordance with the contractual terms accepted by Andres, which include the penalty for unjustified refusal of goods delivered. So,
well, in relation to this scenario, number one, there are three issues to be analyzed. The first question: can Amazonia Deutschland use the European Small Claims procedure to make a claim against Andres? Here in Galicia, people usually answer the question saying, it depends on, but in this case, the answer is only in part, it depends on, is the same. So there are a number of different issues to be considered. The first relates to the alternative form of compensation referred to in the claim. Regulation of the ESCP regulation in its current wording does not include the possibility of establishing alternative forms of compensation, and the form provided in Annex 1 makes no mention of any such alternative. Neither, however, does it preclude the possibility explicitly. In view of the subsidiary nature of national procedural law in such cases, if an alternative form of compensation is allowed by the procedural legislation of the member state of enforcement, it should also be allowed by the ESCP, provided it meets the requirements of an ESCP. In the case of the claim in question, only one of the proposed forms of compensation may be claimed through an ESCP, owing to the quantities involved. The primary claim is perfectly admissible under the existing regulation, since the amount sued for is less than €5,000, not counting possible interest and cost, as we have seen. However, in the case of the alternative form of compensation proposed, the value of the return item, plus the value of the penalty for the refusal of goods delivered for reasons other than those stated in the contract is in excess of 5,000 euros. This conclusion is not affected by the fact that the claim is non-monetary. Unlike the European Order for Payment Procedure, the ESCP is not limited to monetary claims, but may also refer to goods or even service as reflected in Annex 1. The court of origin should therefore reject the claim, pending its modification by the claimant to meet the financial limit established by the ESCP. The second question is the following. In which member state should Amazonia Deutschland present its claim? In this sense, jurisdiction over the ESCP is determined according to the rules provided in regulation in Brussels 1 bis. In Brussels 1 bis. In the case of the claim in question, the special terms of jurisdiction over consumer contracts provided in Brussels 1 bis apply, since, in accordance with Article 17, paragraph 1st, letter C, claims involving consumers are subject to special jurisdictional rules when the contract has been concluded with a person who pursues commercial or professional activities in the member state of the consumer's domicile, or by any means direct such activities to that member state or to several states, including that member state, and the contract falls within the scope of such activities. So this condition is met in this instance because the trader company website is designed to promote and offer sales throughout the European Monetary Union. Article 18, paragraph 2nd, Brussels 1 bis states that proceedings may be brought against a consumer by the other party to the contract only in the course of the member state in which the consumer is domiciled. For this reason, the initial request for an ESCP must be made before the Spanish courts. If presented before the courts of any other state member state, the claim will be rejected by the court ex officio in accordance with the powers of control provided in Article 4, paragraph 4, number 4, ESCP, where the claim appears to be clearly unfounded, or the application inadmissible, or where the claimant fails to complete or rectify the claim form within the time specified, the application shall be dismissed. So rejected. And finally, in relation to the last question, question number 3, we have to ask ourselves, does the court have the power to examine ex officio the possible unfairness of the terms of the contract at issue, specifically in relation to refusal of return or refund and the penalty clause against the consumer for unjustified refusal of goods delivered? I think that Julio has made reference to this question in his intervention, but in any case, we have to conclude that there is no explicit legal answer or case law on this question with respect to the ESCP. Nevertheless, by analogy with the judgment of the European Court of Justice in relation to the civil proceedings in general and to the European Order for Payment Procedure in particular, the court may indicate the unfairness of contract terms to detriment of the consumer in its assessments of the claim as part of its power to inform the claimant of any possible errors or omissions in the claim commencement form. And that according to the aforementioned Article 4.4 of ESCP. Should the claimant fail to rectify the point, the presence of unfair contractual terms may be used as grounds for the rejection of the claim. In the case of claim in question, the claimant's application for the alternative form of compensation would be rejected on the grounds that it exceeds the financial limit established by the ESCP. The second part of the compensation terms would not be subjected to examination by the court, therefore, but the refusal of return of the items purchased would be. Yes.
Remember, the facts are the same, but...
To conclude, let us now look at the second scenario.
Scenario 2. Given the circumstance and the problem of recovering the trade price of the items for Andres, Amazonia Deutschland decides to adopt the usual course of action at the company of assigning the credit claim to the debt collection management company. We recovered Inc.
Okay.
Headquartered in Spain. Here in Spain.
In this case, the question is the following. Can the debt collection management company apply for an ESCP to enforce the debt? This issue has been settled by the judgment pronounced by the European Court of Justice, date 22 November 2018, in the matter of CSC Energy, in which it ruled that Article 3 1 of the ESCP should be interpreted as meaning that the concept of parties refers only to the claimant and defendant in the main proceedings, and therefore excludes other persons who may be involved in the dispute, including individuals intervening in the proceedings in support of the main claimant. According to Articles 2 and 3 ESCP, disputes in which both claimant and the defendant have their domicile or habitual residence in the same member state, as the court seized of the proceedings, do not come within the scope of the regulation. In the scenario in question, the main claimant will recover Inc., the defendant, Andres, and the seized court are all domiciled in Spain, so ESCP does not apply, and the claim should be dealt with in accordance with national law. Okay, I think that is more or less the content of our intervention. So thank you very much for your attention. We are not able to say thank you in Slovenian, but we have written that.